assault, resist, or obstruct, in that you did assault, batter, wound, resist, obstruct, oppose, or endanger Officer Daniel Gurtz, a police officer of the Gaylord City Police Department, who you knew or had reason to know was performing your duties. That is a felony offense that has a maximum penalty of 2 years and or a $2,000 fine. Do you understand the name of that offense, ma'am?
I'm not really sure what you're saying, but kind of. I have a resisting arrest?
Yes, that's count one. As a maximum penalty of 2 years and $2,000. Do you understand that?
Yeah.
Count two is the same kind of charge, resisting arrest. The name of it's called police officer assaulting, resisting, or obstructing. It says that you did assault, batter, wound, resist, obstruct, oppose, or endanger Officer Jacob Dupuy, a police officer of the Gaylord City Police Department who you knew or had reason to know was performing his duties. That also is a felony offense with a 2-year and or $2,000 maximum penalty. Do you understand the name of this charge in count two is also police officer resisting? And you also understand that that has a 2-year, $2,000 maximum penalty? All right. In addition to that penalty, there's also a habitual offender notice being sent called fourth offense notice, which enhances the penalty. It says that you did on or about October the 13th of 2020 were convicted of the offense of resisting and obstructing police in the 46th Circuit Court of Otsego County. On or about February the 5th of 2019, you were convicted of resisting and obstructing police in the 46th Circuit Court for Otsego County. And on or about February 5th of 2019, you were convicted of the offense of attempted arson preparation to burn a building, also in the 46th Circuit Court. And because of that, the underlying two offenses have a maximum penalty of, Ms. Brucker, this says life, but I don't know that is it third offense that doubles it, or is it fourth offense that mandates the life sentence? Excuse me, the 25-year sentence.
I'm sorry. I think it should be 15 years, but let me double check that. I might have selected the wrong prompt when I did that. I'm sorry. If I could just have 1 second.
Yep, go ahead. Ms. Brink, she's going to check to see if the information that I have on my paper here is accurate.
All right.
It would be 15 years, Judge, and I'll get that corrected.
All right, thank you. So, Ms. Brink, with the habitual offender notice, the maximum penalty is now 15 years in prison. Do you understand that?
Yeah.
Count three alleges that you did commit the offense of retail fraud in the second degree. That is, that in a store or its immediate vicinity, that is Walmart, when it was open to the public, you did steal property of the store that was offered for sale at a price of $200 or more, but less than $1,000. That's a misdemeanor offense. It has a maximum penalty of 1 year and or $2,000, up to 3 times the value of the property that was stolen. You understand the name of the offense to be retail fraud, that is shoplifting?
Yeah.
You understand the maximum penalty is up to 1 year in jail and or a $2,000 fine?
Okay.
All right. Right now you have certain rights. I want to tell you what those are. You have the right to plead guilty, not guilty, or no contest, or excuse me, stand mute. You have the right to have a trial by a judge or by a jury, and you have the right to have an attorney. As to your trial rights, you have the right to see, hear, and question all the witnesses. You have the right to present your own witnesses and evidence and get an order from the court called a subpoena to require those witnesses to appear and testify. You have the right to testify yourself, or you could remain silent. And if you chose to remain silent, that silence could not be used against you. You also have the right to be presumed innocent until proven guilty beyond a reasonable doubt, and have that burden of proof remain with the prosecutor at all times. Finally, at trial, you'd have the right to automatically appeal if you wanted to any error that occurred. However, if you enter a plea, you'd be limited to asking the court for permission to appeal, and that might not be granted. You understand the rights that I've just given to you?
Yeah.
You have any questions about any of those rights?
No.
All right. Mr. Brown, have you talked to Ms. Brink about court-appointed counsel?
I was not really able to get that far, Your Honor, but I am going to say that she is. I currently represent her on a few other cases.
All right. Ms. Brink, I'm going to appoint an attorney for you. In the past, we've dealt with each other and you've been eligible for court-appointed counsel in the past. So I'm going to do that now. Mr. Gilo is going to assign the specific attorney. It may be Mr. Brown, it may be somebody else. But right now I'm going to enter a not guilty plea on your behalf in order to protect your rights until you have a chance to speak with your attorney. Because you're charged with felonies, I'm also going to set some court hearings on a quick basis so that those protect your rights as well. The first one is called a probable cause conference. That's a chance for your lawyer and the prosecutor to discuss the case quickly to try to resolve it. That'll happen within the next 7 days. We'll also set a preliminary examination date within the next 21 days. That's a chance, that's an opportunity for the prosecutor to prove in court a small amount of evidence called probable cause that you committed the crimes that you've been charged with. Do you have any questions as to the hearing dates that we just talked about?
Oh, I didn't really hear you though.
Do you want me to explain what a probable cause conference and a preliminary examination date is?
Oh, no. I get it. I thought you were setting dates, like giving me dates.
Nope, not yet. All right, what I'm going to do next, Ms. Brink, is I'm going to ask the lawyers about bond, and then I'm going to give you a chance to tell me what you want me to hear about bond as well. So, Ms. Bruker, could you, any thoughts on bond?
Ms. Brink is currently on bond for a trespass charge that we're set
No, I'm
for.
not. There was no bond set.
Okay,
Ms. Brink, she gets to talk, and then you'll have a chance to talk afterwards. So I'll listen to you what you want to say, but you got to let her talk without interrupting her, please.
and she's set for an upcoming trial in that case. She was recently convicted of assault and battery back in February. And she does have a history of felonies and misdemeanors on her record that are assaultive as well. I would ask for the standard terms and conditions of bond, including that she not re-enter the Walmart store. I would ask for the court to order that she report to community corrections. I'd ask for the court to order that she follow through with any of her community mental health appointments and treatments. It appears that this crime, as well as her trespass charge, are probably related to some of her mental health issues. So I wrote on the bond sheet a $10,000, 10% bond. I'll leave that to the court's discretion. When Ms. Brink is out in public, she violates the law, she fights with police. We need to make sure that she's safe and the public are safe. But I also recognize that she does need her mental health treatment.
Mr. Brown, your thoughts?
Your Honor, as the court stated, is familiar with Ms. Brink. She does suffer from some mental health issues that she's seeing CMH for. I would ask the court to take that into consideration when setting a bond if she has appointments coming up, but definitely don't want her to miss that. If she's taking any kind of medications, I want to make sure that she is getting the medications that she needs. Other than that, Your Honor, I would leave this up to the court's discretion.
All right, Ms. Brink, this is your chance to tell me what it is that you want me to know about your bond. I would simply caution you, if you don't make any statements about the underlying facts of this case, because we're recording this and it could be used against you later. Is there anything else that you want me to know about bond?
Well, I have no money because I went to prison once already and it destroyed my life and I have no way of working, so I have no money. So that should be taken into consideration. I'm pregnant, so I'm going to need OBGYN care. And when I left the hospital just recently, I told them, please make my appointment for the next day when I get discharged, because I cannot wait that long without seeing someone. I go crazy in the public because I have been to prison and I don't understand people anymore. And they didn't do that. So I went nuts because I found out I was pregnant. So all of that needs to be taken into consideration. $10,000 isn't too bad, but I'm not going to be able to make bond. So it doesn't matter. You're going to keep me in jail and probably send me to prison for this anyway.
Have you been to see a doctor yet about your pregnancy?
No, it's too early to even get a positive pregnancy test.
Are you currently working with anybody from community mental health on your treatment?
Yes, I am. Dr. Gurman is my doctor, and I'm supposed to be getting hooked up with ACT as well. They were gonna help me and like get a plate because I'm homeless. And because my parents have dementia, they don't understand that I'm homeless. They won't take me into their house. They keep calling the police on me because they don't recognize me anymore because I went to prison.
All right, so do you think it would be a good idea for you to start working with Dr. Gurman again?
Well, I have a complaint with CMH filed against him for not being fair and violating my rights. So I prefer a different doctor. I've mentioned that to the court once. That hasn't been respected at all. But I need to work with ACT and CMH because I have depression, anxiety, and I don't know.
All right, are you
Depression
taking any
and
medication?
anxiety.
All right, thank you. Are you taking any medications right now?
No, I'm not because I'm pregnant and I want to make sure that it's not going to negatively affect this pregnancy. Even though you're going to take this child away from me. I'm not interested in hurting this child.
Good, I'm glad to hear that. All right.
Yes. It's probably best for me to stay in jail for as long as possible because I have nowhere to go. So when I get out, I'm going to go back to violating the law so I can come back to jail.
Well,
No, that's the fact, Larry. I went to prison.
Don't
I cannot
you-
work. Nowhere will hire me. I have no money. I'm stealing food like an idiot.
okay, I don't want you to go into that, please.
Well, I'm just saying. He's asking questions. I'm telling him what needs to be considered with my bond. A PR bond would be nice so I can go look for work and take care of a baby, but that's not going to happen. I'm realistic.
Thank you, Ms. Brink. That's all the information I need right now.
Are you going to set my bond?
I'm thinking about that right now. So yes, ma'am, I am.
Oh,
Just give me a
okay.
minute.
Sorry,
Just
you
give me
didn't
a
say
minute.
anything, so.
No, that's all right. Yeah, I understand.
I'm half nuts too because I haven't seen or talked to my children that already exist in a very long time. So I can't help it. You know, I really can't. I don't even understand that I'm breaking the law. My parents are nuts. I'm getting no support out here.
Well, we're going to try to get somebody to come into the jail and help you with that. All right, we are going to set bond at $10,000, 10%, cash surety or 10%. The reason for that is her past history of violent behaviors, assault, and resisting and obstructing. There does need to be some amount of bond that protects the public. However, because she has a mental illness, it also needs to have some treatment part of that as well. So the requirements, Ms. Brink, are that you appear for any scheduled court dates, that you abide by the judgment of the court, that you not leave the state of Michigan without the permission of the court, that you not commit any crime while released, that you immediately notify the court in writing of any change of address or telephone number. You may not use any alcohol, marijuana, or illegal controlled substances while out on bond. You must participate in a substance abuse testing or monitoring program through community corrections, and you must comply with all community mental health treatment programs. And that includes doctor's appointments and medication as prescribed. You also may not enter the Walmart in Gaylord, and you must contact community corrections upon your release. You have any questions about the bond?
No,
Ms.
I'm not
Brink?
going to be able to make bond.
Well, I set it at a point, you'd have to post $1,000. If you are able to, then you need to do what CMH tells you to do. Deputy, I asked that you guys call CMH and ask if they can send somebody to the jail to evaluate her and see if they can get her on some prescription medication.
Yes, sir.
Can we make an OB? Well, whatever. I'll just tell them and they'll work with me on that way.
All right, that's all for today. Thank you, Deputy.
Okay.
I'm not even sure why I'm still required to pay on these children, and I don't have responsibility toward them anymore.
We're on the record in Brink versus Hildebrandt, case number 11140050. The record should reflect Ms. Brink is present today by Zoom video. Ms. Kraus, can you tell me the status of this file today?
This hearing was adjourned from August 5th to allow the plaintiff to obtain friend of the court forms regarding disability and complete and submit them back before today's hearing. No information has been received regarding her inability to work. The only contact the office has had with the plaintiff is on August 12th when she dropped off a letter requesting to sign off her rights to the child and support to stop. Friend of the court staff did indicate she may need to reach out to probate court to move forward regarding that information. And outside of that, the plaintiff has a support obligation of $197 and a balance of $8,709.16. The last payment was received in February in the amount of $206.47 from a prior income withholding.
Okay, Ms. Brink, why did you not submit those forms as you were ordered to at the last hearing?
I never received them.
Okay. Did
They
you
were
go in
supposed to have been mailed to me.
Did you go in to get the forms?
They were supposed to have been mailed to me. That's why I provided my address at the last court hearing.
Okay. Did you do anything to follow up with that at all?
I mean, it's not really my responsibility when someone doesn't do their job.
Well, it's your responsibility to pay your child support payments, and if you don't
But
pay
that
those
has nothing to do with the disability paperwork.
Okay, I'm not going to argue with you. We went through this. Yeah, you are, and we went through this at the last hearing. We confirmed your address. We told you
so that they could be mailed to me, which they were not.
They were mailed
and I
to
would
you.
like to sign off my rights to my children. And Devin said that he would not fight it. Bill did not fight it. He came and he signed. And when it came time for Devin to sign, he didn't show up. And I have a text message saying that he doesn't want, or that he wouldn't fight me on signing off my rights to Lila or John. So I'm not sure why he didn't sign the paperwork.
So you still are the parent and you still owe the child support.
But I'm requesting the court to terminate my rights to my children. She has a stepmom that can adopt her. I don't want anything to do with her anymore.
Well, there's a process for that, and that process hasn't occurred yet, which means
okay, well, I've asked for that process to be started a year ago. This is the second time I'm bringing it up.
Okay, well, you have to do more than just ask. It's up to you to
well, that's why I had the document written up and by an attorney, and so that Devin would sign the paperwork, and he said he wouldn't fight me, and then he didn't show up to sign it. So I don't understand what the big problem is.
Okay, so how are we going to deal with you paying your child support till that happens then?
I don't know. I have a paycheck coming from Boyne River, and you can have that. Okay. But other than that, I have $34 to my name. My house is for sale, and I'm living in my car.
When are you getting that paycheck?
I don't know. It should be garnished. I probably won't even get a paycheck. It should be garnished by child support.
Do we have an income withholding, Ms. Kraus, for any employers with Ms. Brink?
There is a potential income withholding, but it wasn't reported. So outside of her indicating where she's employed today, that process could take 6 to 8 weeks. So I can't guarantee that monies would be withheld from that paycheck.
Yeah, it should be. I've never had a problem with it not being withheld in the past.
Okay, well, we don't have the information from your employer, right? Ms. Kraus, is that what you're saying?
Yes,
She's
they
never-
do.
Correct.
They reported it.
Hold on, Ms. Brink. Ms. Kraus?
An income withholding was sent, but until monies are withheld, we wouldn't be able to indicate if that amount would be withheld. But the employer was not reported. It's pending, so I can't guarantee that the employer received anything.
They did.
Okay.
They told me.
Well, we haven't received any money from them, so apparently they haven't.
I haven't gotten the check yet. I haven't even been, I get paid every 2 weeks. And
Okay.
I've already lost the job. They already fired me.
So you're
I'm
not
not
employed.
sure.
You're not employed is what you're saying.
Not currently, no. I lost the job. I got fired. The bartender didn't like me.
Okay. What about the disability? Where are you at with that?
I filled out all the forms that they requested from me and mailed them back in the timeline that they gave me. But I'm living in my car, so I don't have access to my mailbox anymore. So I have to contact disability today after I get off the phone after I get out of court and report my address to be at my parents' house. Now, there's no guarantee that I'm going to get my mail. My parents don't like me. So there's no guarantee that they're going to tell me that the disability paperwork comes. I'm going to have to, I don't know what I'm going to do because I don't have gas to get to their house. And they have me blocked on the telephone.
Your Honor.
Okay. Yeah, go ahead, Ms. Kraus.
In regards to her being homeless, she may be able to reach out to the local post office. They may have something for her in regards to obtaining a P.O. box, but she would need to check further into that.
Well, I don't have money to pay for a P.O. box.
They may have some options for you regarding if you're homeless right now. I don't know the details in regards to that, but it is some information that friend of the court has received in regarding post offices when people are homeless.
Okay, I'll look into that.
All right, well, here's Ms. Kraus, has there been, how many findings of contempt has there been in this case on Ms. Brink?
This would be a first finding.
Okay. All right, so Ms. Brink,
I'm not in contempt, Your Honor. I have no problem paying it. It's just I can't get a job because I have felonies. No one wants to hire me.
I do
I've already put
consider
out more applications. I'm not in contempt, though. I have no problem paying. It's just that I can't get a job. No one wants to hire me.
you are in contempt, first of all. I find specifically that you are in contempt because you aren't doing any of the things that I ordered you to do the last time, and you can't just
Your
say,
Honor,
well,
like what?
like fill out the forms for your disability.
They
Communicate
weren't
with-
mailed to me. How can I
You
fill out
just-
forms that weren't mailed to me?
I'm not going to
I
argue
called
about.
and asked.
Okay,
I called
now
and
I'm-
asked.
Now I'm finding you in contempt for continuing to interrupt me during this court hearing and inhibiting the court's ability to conduct this hearing. You're continuing to talk over me. I'm trying to explain to you.
I asked you a question.
You just told me that you're not getting mail at your parents and there's no guarantee that you're going to get your mail. So how do you know that you didn't get this? We sent it to the address that you gave us.
And I was living there up until Friday.
It's not my problem that you aren't getting your mail. All we
I
can do
am
is send.
getting my mail.
Obviously, you're
Not
not.
making sense, Your Honor.
All we can do is send it to you at the address that you give us.
And you
then
didn't.
It's up to you. So you haven't followed through with what you were required to do.
Yes, I did. I called the child support office and asked about it, and they said it was too soon for me to be calling.
I'm going to mute you now so that I can say what I need to say for the record here, because you're continuing to talk over me and I'm not able to conduct this hearing. So the court adjourned the previous hearing in August to give you an opportunity to submit the forms that were required to be submitted. That's your responsibility to make sure that that's done. We had this colloquy the last time about your address. You gave us an address. That's the address we've been using. If you haven't received the mail, that's between you and the post office and you and whatever is going on with the address that you gave us. All we can do is send out forms. If you didn't get them in the mail, then it was your responsibility to contact the friend of the court, go to the friend of the court, make arrangements to get those forms and fill them out, but that's squarely your responsibility. It's your responsibility to pay child support for your child. That's still your child. Your parental rights haven't been terminated. As far as I can tell, you haven't done anything other than say you want that to happen, to make that happen. So you haven't paid child support. You haven't complied with any efforts of the friend of the court to give you options outside of paying child support. So the court finds that you are in contempt. Because this would be a first finding of contempt, the court finds that you should be sentenced to 45 days in the Otsego County Jail. The court is going to order that you turn yourself in to the Otsego County Jail by 5 p.m. today. That's September 3rd, 2024, to begin serving the 45-day sentence. If you fail to turn yourself in to the Otsego County Jail by 5 p.m. today, then the court will issue a bench warrant for your arrest. Ms. Krause, if you can prepare an order to reflect the ruling of the court on that today.
Yes.
All right. That's all for this hearing today. The court's going to disconnect from Ms. Brink at this time.
Two matters involving Chelsea Brink, both friend of the court matters. First one is Chelsea Brink in 2013-15199-DC. And the second one is involving Chelsea Brink. It's 2011-14050-DS. Both of them looks like arraignment cases on failure to pay. So do we have
Here, I believe. I didn't show up to court on Monday. My alarm didn't go off by the time I woke up and realized it was too late to join. My attorney did go though, and I did pay $100 towards my child support before that. So that's where I'm at.
all right, let me hear from the friend of the court first. Who do we have speaking on the behalf of these cases, please?
Depends on which case you want to handle first.
You got both, one for each?
Yes.
All right. I guess it doesn't matter. Let's do William Mason, William Mason versus Chelsea Brink, which is the 213 file. As to that case?
That would be me.
All right. What is it that the friend of the court is asking for in this case?
Well, we are seeking first contempt as we received information about a property that Ms. Brink previously disclosed in another hearing has recently sold, and she has not made any efforts to make any significant payments out of available.
I paid.
Or exercise due diligence.
I made a payment of $100. That was all I could afford.
Ms. Brink, you're going to be given an opportunity to have your say. I just need to hear it from everybody at their time to speak so that we're not talking over each other. So this is the friend of the court's turn. I'm going to give you your chance to speak in just a minute. So don't worry. You'll have your opportunity. Let them speak and then I'll let you speak. All right, go ahead.
So the monthly obligation that Ms. Brink has is $202 plus an additional $50 ordered on arrears. The balance on this case is $12,753.72.
All right. Now, Ms. Brink, I'm going to turn to the other case. So we have both of them out on the table first, and then I'll let you have your opportunity as well. So the other case is Chelsea Brink versus Devin Hildebrandt. That's the 2011 file. So Ms. Krause, could you update me as to that one?
Yes, her obligation, she's a plaintiff on that case. Her obligation is $197 a month. The arrearage in this case is $10,209.16. We did recently receive a $100 payment on April 15th for this specific case. Out of that $100, $49.37 dispersed to the case. Chelsea did report an employer on March 30th and also indicated a change in address, but refused to submit that in writing. It was verified at a later date with postal information, but it does appear that she's no longer employed at that employer as of March 27th.
All right. Now, Ms. Brink, this is your opportunity to tell me what it is that you want me to know about all of those things. So go ahead, ma'am.
Yeah, well, first, I did make $100 payment. That was all I could afford at the time. I'm homeless. I've been homeless for quite some time now, so I'm kind of drifting, going where I can. I was working at Italia Gardens, and I'm not sure what happened to be able to explain why they fired me, but they did. He just basically said things weren't going well. I had a workman's comp claim that he didn't want to pay, so there was that piece of it.
What was the name of the business that you were working at?
Italia Gardens.
And where's that located?
It was in Davison, Michigan.
All right.
So, but that's no longer.
Yep.
And you know, my kids have been out of my life for 10 plus years now, and both of their parents are remarried. My son's been adopted twice. My daughter has been adopted once. I'm not even sure why I'm still required to pay on these children. They're not in my life, and I don't have responsibility toward them anymore. So it seems to me not fair. A lot of this front of the court totals, you know, the monetary amounts got accumulated while I was in jail for a year. That still hasn't been cleared up, and I doubt it ever will be. But I am making my best efforts. I'm in jail. I'm not sure how long you want to keep me in here, but when I get out, I plan on looking for a job again and starting the whole process over. Like I said, I'm homeless, so it's hard for me.
How long did you work at Italian Garden?
About 6 weeks.
Did you make any payments other than $100?
I reported the income to the front of the court, and they said that they would take it out of the checks. I never even got my last paycheck because I had to come back up north. So that's out there somewhere still. But no, the $100 is all I could afford at the time. I had intentions of making $100 payments every month, you know, from here forward. But right now, you know, that was only a couple weeks ago. What day did she say? The March 20th? Something?
You said you were employed in March, but you're no longer there. You made a payment in the middle of April for $100.
Middle of April, yeah. So it's only been a couple weeks, you know. Not even really. Today's April 30th, so middle of April. I mean, 15 days ago at the most, 2 weeks ago at the most, I made that payment. You know, I'm exhausted because I'm homeless. So not that that's an excuse, Judge, but I've never missed court. Never. I don't do it. I don't miss it. And Larry was there, you know, so I'd rather you just sentence me now so that I know what I have going on moving forward and can be prepared in here for what I need to do.
Well, what you've been telling me is that you can't afford to make payments, as opposed to, yeah, I can't afford to make payments and I didn't.
I can't pay the whole amount. I can't pay the whole amount. I'm homeless. I'm barely making ends meet as it is. You know,
you're not asked to make
from walking. It's hard.
Okay. Have you filed a request to lower your child support based on your current income levels?
Yes, I did. I asked front of the court to mail it to me. They did not do that. They said that they required me to change my address with them on paper, but I was clear down in Davison, Michigan, and I couldn't get to the courthouse down there. I was on foot, you know, and I couldn't get to the courthouse down there. And to be able to mail in the paperwork that they were requesting. You know, it's on my to-do list, but, you know, I've been traveling, going from place to place, you know, couch surfing and whatnot. So, sleeping in my truck.
Your Honor,
Yes, ma'am.
in regards to motions, the conversation that I had with her on March 3rd in regards to asking for case information on both of her cases, the friend of the court did, because the motions didn't have any case-specific information, printed out a postal to send to her with those motions to the address that she indicated that she was residing at. So we did do that in regards to previous contact when reporting employment.
I never received them.
We've had discussions in regards to when you start working, payments are expected to be paid when you receive paychecks, because income withholdings can take 6 to 8 weeks. But when she does obtain a job, she's usually not there long enough for an income withholding to send money. So there was never any money received from the employer that she reported.
Right, which is why I made the $100 payment. You know, and trying to get my child support, you know, the first $12,000 or so of that back child support is all from when I sat in jail for a year. And that's just not right or fair to me. And actually, it's probably more like 19,000.
Ms. Brink, when was the last time you were in jail for a year?
2017.
That's
when my child support first became activated. And they did it while I was sitting in jail for a whole year. They accumulated it for a whole year.
Ms. Brink, that's 8 years ago. Even if you were incarcerated in 2008.
I know, but I'm saying I'll never be able to pay that money back. Not at this rate. And I'm trying, Judge. It's not for a lack of effort. I walked the entire main street of Davison and put an application in at every single business. Every single one. Down the street and back the other way when I was living down in Davison. And I have full intention of doing that up here again. And I'm going to go to Traverse City and stay in the homeless shelter or stay in my truck. You know, I mean, who wants to hire a smelly person that's homeless, though? I mean, I'm doing the best I can, Judge. It's hard. I relied on my child support money to pay my bills when I had full custody of my kids. Plus work, and when I lost my career, I lost my kids, and that's all my money. I can't do it. I just can't, Judge.
Ms. Brink, the issue is when you were working, you didn't send any money into the front of the court. $100 in 6 weeks is not a payment out of each of your paychecks.
But that's the thing, is that I only got paid 2 times. I didn't get 6 weeks worth of paychecks. I only got 2 paychecks.
Which would have been at least 4 weeks worth of paychecks, right? You got paid every other week?
No, I got 2 paychecks of the whole time. I don't even think I was there 6 weeks. Honestly, I don't. But I only got 2 paychecks the whole time I was there. I promise you, Judge. I wouldn't lie to you about it. I know that we're in court. I'm not going to lie to you. And I didn't even pick up the second paycheck because I had to come back up north.
All right, Ms. Brink. Doesn't sound to me like you believe that you've done anything wrong in this case, so I'm going to set this matter for a hearing.
Judge, I'm saying I know I missed court, and that's why we're here talking about this again. And Larry advised me that you weren't going to pursue jail time or anything like that because I made the $100 payment and I'm putting in effort to find a job again. And
Your Honor, if I could just mention a couple of things. I don't know how much Your Honor knows about the background. I have represented Ms. Brink in the past. Back in I know she said she did a year in jail. Back in 2021.
I went to prison I was locked up for 4 years from 2017 till 2020.
Yes, there was a prison stint. I also have some notes here back from June of 2023. There was an MI petition that was filed as well, just so the court has a better
I don't know that, Larry.
Understanding of what's going on.
All right. Ms. Brink, are you telling me that you want to admit responsibility to failing to appear when you were supposed to?
I admitted to responsibility to that. Absolutely. I screwed up. My alarm didn't go off. I was exhausted. By the time I woke up, it was 10, 11 o'clock in the morning. And I thought, oh, real nice. They're not going to accept me now. And what do I do? So I just didn't
Right.
go to court, which I guess looking back, I guess I probably should have tried to join in, but I figured the court was closed. And Larry texted me the same day or the next day and said, now you have a warrant. And I said, okay.
All right, Ms. Brink, I'm going to do this. I'm going to adjourn today's hearing for 30 days. I'm going to set a PR bond so that you can be released. The conditions of that are that you have to notify the friend of the court of a mailing address where you will pick up your mail on a regular basis.
Okay.
And so that you know when you're supposed to be in court. The second condition of that PR bond is it's going to be a $500 PR bond.
Okay.
The second condition of that is that you submit 10 applications a week to the friend of the court indicating that you have applied for jobs, and as soon as you are able to obtain a job, that you notify the friend of the court of that.
Okay.
The third condition is that once you are employed, you begin to make some payments every paycheck. You're not going to wait for income withholding. You're not going to do anything else. You're going to make some payments on both of these cases every paycheck.
Yes.
You
Sir.
understand each of those three conditions?
Yes, sir.
All right. So in
I
each,
do have a question. So, okay.
hang on, let me finish. In each of these two cases, you will have a $500 PR bond. Okay. So that means if you fail to appear, you'll owe me $1,000 total. You
Okay.
understand that?
Yes, sir.
All right.
I
Now
don't
what
have to
is
pay anything
what is
to-
your question? I'm sorry, repeat that, please.
I don't have to pay anything today to get out.
That is correct.
Okay.
You don't have to pay anything today to get out. I'm giving you a big break here
Yes, you are.
because
Thank
you owe an awful lot of money, but I think that you have done something to show me that you're trying.
Yes.
That's the $100, and you've made an admission that you failed to appear and gave me a good reason for it.
Right.
But you've got to do better than you have been. You have to
Okay.
find a job that you can stay with. You have, and if you can't get that one, you got to get one that at least allows you to have a place to live so that you can make regular payments. Do you understand what I'm saying to you?
Yes, sir. Yes, sir.
If you believe that the numbers that the friend of the court says that you owe are wrong,
Uh-huh.
you need to file a motion to have me take a look at it so that I can correct that for you.
All right.
All right? You understand all of that?
Yeah, and when I get out, maybe I can file to see about having my child support adjusted so to
That's
reflect
correct.
more accurate income.
Yes,
But
but
it's
you need
not
to
so
file the
bad.
paperwork first. File the paperwork with the friend of the court so that I can review it, set a hearing date, and take a look at it.
Okay.
All right?
Thank
That's
you.
all for today then. Thank
I
you very much.
appreciate you. Yeah.